Hello and welcome to a fresh episode of Legal Wrangle. In today's episode, we will be presenting before you the latest development in the GST taxation regime. We have incorporated a landmark decision of Supreme Court as well as other important decision of High Court and Authority of Advance ruling. Without much ado, let's proceed to our first case. The petitioner company had challenged the validity of compensation cess levied in new GST regime. The respondent used to pay clean energy cess, which was one of the nature of excise duty on the product of coal and was collected upon the removal of raw coal, raw lignite and raw peat from the mine.
The Clean Energy Cess was repealed by the Taxation Laws Act 2017. Thereafter, Section 18 of the Constitution Act 2016 enabled the Parliament to levy a cess for 5 years to compensate the states for the loss of revenue on account of migration to GST. When the petitioner approached the High Court to challenge such a levy, it only received partial relief.
On hearing the contentions of both sides, the Apex Court held that the state compensation cess was with respect to GST and so is a tax. Also, when the Constitution empowered Parliament to compensate state for loss of revenue by law, the term law had a wide scope and also included levy of any cess. Hence, the court held that the Compensation to State Act 2017 was not beyond the legislative competence of Parliament and that it did not contravene the provision of Constitution Act 2016. The Apex Court also clarified that the Compensation to State Act is not a tolerable legislation.
The Apex Court also noted that the levy of compensation cess is an increment to the GST and that such a levy is permissible in law. In response to the petitioner's plea to adjust set-off of clean energy already paid till 30th June 2017 against the compensation cess payable, the court noted that such a set-off was impermissible considering that both levies were entirely different from each other. The court also noted that both served different purposes, that the clean energy cess had no connection with the state compensation cess.
The Apex Court further noted that the given credit or set-off payment is a legislative policy which had to be reflected in legislative scheme. The bench observed that the Compensation to State Act or the rule did not provide any set of clean energy cess already paid June 30, 2017. Hence, the court held that the petitioner was not entitled to such set-off. The petitioner was dismissed. Let's now move to our next case.
The premises of the assessee company engaged in dealing in PVC resins and food items were raided by DGST officials during the period of the dispute. The assessee was also directed to produce books accounts in this regard. It sought 24 hours time to procure such material. However, the department sealed the premises. The petitioner claimed that the DGST lacked the statutory power or authority to direct indefinite sealing of the premises.
On hearing the matter, the High Court held that the authorization issued in form GST-INS-1 to the DGST official to break open, seal and search premises under Rule 139 did not mention the petitioner company's name and in fact simply listed the premises. The High Court also noted that Section 69(4) of CGST Act only authorized officials to break open locks and conduct search and examine books and documents, that too if they encounter resistance. Hence, the bench found that sealing of premises was completely illegal.
The bench also noted that the petitioner could justifiably be restrained from using the premises only for as long as was needed to secure the necessary material. In such circumstances, such restraint could not have been made indefinite. Hence, the department was directed to lift the seal within 12 hours and return possession of the premises to the petitioner. Let us proceed to the next case.
The applicant company is engaged in dealing in motor vehicles. Its business requires it to mandatorily acquire vehicles for demonstration purposes for the principal supplier. Such purchases would be capitalized in the books of accounts after excluding tax components. The applicant would later sell the vehicles for their book value by paying applicable taxes. The applicant sought ruling on whether input tax credit could be availed on such motor vehicles.
The authority for advanced ruling observed that the capital goods used in the course of furtherance of business were entitled for ITC. Also, input tax paid by vehicle dealers for purchasing motor cars used for demonstration purposes could be availed as input tax credit on capital goods, be set off against the output tax payable. Let us now move on to our last case.
The applicant company is engaged in providing financial services such as stockbroking, share broking, marketing of IPOs of companies and mutual funds, and providing corporate advisory services. While such services were not taxable under erstwhile VAT law, upon migration to GST, the applicant claimed input tax credit on the closing stock of computers, laptop, and other goods. Such input credit was claimed under transactional provisions and on goods it possessed as June 30, 2017. Hence, it sought a ruling on whether computers and laptops qualified as input for availing transactional input tax credit under Section 140 of GST Act. The applicant also sought to know whether in such cases input credit could be availed for the VAT paid.
The authority observed that the computers, laptops used to provide services were excluded from the scope of Section 2 of the Kerala Value Added Tax Act, which defined capital goods. It also observed that since the applicant was a service provider, it was ineligible to avail input credit on computers and laptops during the transition period.
The authority also held that the proviso to Section 140 is specific to the point that input credit is not available under erstwhile law, could not be claimed as a transitional credit. Moreover, Section 140 of the GST Act covered credit of eligible duties in respect of input held in stock as held on the appointed day, in view of which the computers and laptop used by the applicant would not qualify as input for availing transactional input credit. Thus, no input credit could be availed on VAT paid. This brings us to the end of today's episode of Legal Wrangle. Please stay tuned to www.tioltube.com for our upcoming videos. Please also feel free to share your views with us at editor@tiol.in. Thank you for watching and have a nice day.